Oh, that's right. Then I got to go to that one too now. Okay, so yeah. Oh, there. Okay, cool. Now it's active. See, what's up? Hmm. Okay, so I gotta stop streaming. Okay, fuck. All right. Well, I'm gonna keep going. So this email, so I say straight up, I'm like, James Patrick's trying to reach you, April 6th. Okay, so let's look at this timeline because what he said to the court is just it's wrong. And he's been doing this for a while. So my name is, I said, I'm contacting you at the request of James Patrick regarding his appeal. James has indicated that he has been attempting to reach you to discuss concerns about certain issues that were not included in his appellate brief filed on November 5th. I am relaying this on his behalf to ensure his concerns are clearly communicated and documented. He has asked that the following issues be considered for inclusion through a supplemental or amended brief. Visible shackling in front of the jury during his testimony. Review of appellate case law shows this almost always has led to reversals. Denial of a mistrial after the issue of jury misconduct was raised. Admission of a prejudicial photograph over objection. I said I'm contacting you with his knowledge and at his request, so there's a clear record that he's asked for these issues to be reviewed and potentially raised on appeal. He would also like, and then I changed that from like he would maybe like this, like I'm like I'm instructing you to do this, like, and I understand I'm not the client, but the fact of the matter is that I make it very clear I'm contacting him on behalf of his client since he didn't try to reach out to his client, and so I said he would also like for a copy of his trial transcript to be provided to me as well as to him. If there's a different path procedurally he needs to take, I ask that you write him or let me know and I will relay it to him. He never contacted him until I filed the grievance against him. And then at that point he did because he provided him with 9 of the here I'll move it over. He provided James with 9 of the 11 volumes, but he just was like, nah, let's not even bother giving you your exhibits because crime scene photos are going to be considered contraband in prison. But the thing is, you create a redaction law. Like, why are we having, you were a former assistant district attorney for Dallas. You can do that. It's not that difficult. I've created redaction laws in civil cases, so stop it. So I said, please let me know if you need anything further from him to move forward. So it's like balls in your court, yo. Thank you for your time and attention to this matter. Again, shouldn't have thanked him if he wasn't doing his job. So if then I say, fine, Saturday, April 11th, it's like, okay, you're not responding. I mean, he hasn't attempted to make contact with James, and he's not going to come in on his, he's not going to be the shining knight coming in on the 14th. Like, no. So he had to be told. So I wrote, Dear Mr. Casillas, I am writing this on behalf of James Patrick to relay a formal directive regarding his pending appeal. Now, listen, this is a follow-up to prior unanswered correspondence and James's letter of March 26th, which was returned to sender. And now I have the return to sender. He mailed it to me, the envelope showing that he abandoned an address and he didn't notify the Court of Appeals. I'm going, what is wrong with you? This is a 72-year prison sentence that you are the court appointed attorney. You just were expecting to do a shit job and make sure that and not expect anybody to check your homework. And unfortunately, you got me. Sorry, but I hope somebody would do it for me, which is why I'm doing this for James. That and, a little bit of my own sense of guilt in it, and that's for later discussion. I said, James has reviewed the current brief and is formally directing you to supplement or amend the filing to include the following, and then I put in bold. It's like, we can't miss this, okay? So formally directing, let me begin it. But, come on, butthole. Let's see. Oh, come on. Come on. There we go. Boom. Formally directing you the following preserve constitutional errors. Visible shackling. Decby, Missouri. James was shackled in view of the jury during his testimony without judicial findings of risk, which is required if you're going to do that. This was preserved by objection. He was also in administrative segregation for the year and a half prior to his trial. Jury misconduct. The trial, and I'll go over these portions of the transcripts because I have it, and it's wild. The trial court's denial of the motion for mistrial regarding jurors discussing the case on the elevator. This was preserved by motion and ruling. Prejudicial evidence. Omission of decomposition photos misrepresented as injury evidence, which was preserved via Rule 403 objection. I also found the jurors' notes where they requested certain documents from the judge to look at in the back room. And I noticed they just didn't include anything from Dr. Clayton. And I'm thinking, oh, so, apparently we're going to stick with this. Men can't be victims of domestic violence. They had a mutually toxic relationship, but she was always the aggressor. I don't know why. And then the other thing I want to show tonight is this morning, I guess, I've got a copy of, I looked, there's no arrest record in the exhibits of hers because she was, so this all occurred. Janine died in September of 2023. In February of 2023, she assaulted James and was arrested for domestic violence. In March, she sent this email. Let me find it too. It's like, dude, this is wild. I don't understand how this stuff is not, if it's demonstrative, but I don't see it on the list where it says it was, but how these things aren't submitted for the record. Everything that makes, and James could be a little melodramatic something, but he was not a liar. He could, I'm not saying he wasn't a liar, but but he didn't lie in any substantive way. With me, like with our friendship, and everything that surrounding all of this, you don't read, when you read these text messages, and I want to go through some of them, you're not reading text messages from a woman who was in fear for her life. She wasn't. She was an aggressive person, just like he was. You don't see any fear. And finally when I got bit, I just went, fine, enjoy being Amber Heard and Johnny Depp. And I just said, keep going, but realized that you're doing yourself no favors. But she also managed to send him a text message. So February, she assaults him. March, she sends him a text message saying, here, let me pull this. I'm like, why are we just pretending this didn't happen? And actually, they may not have had this actually at trial, is one thing I was told was a possibility. So that's why I'm looking through the text messages. Let me share screen. Let's see. Share screen so much. Here we go. Oh, whatever. Okay, let me change this up then here. Replace. We'll do that. We'll do entire screen, but that one. Okay. There's so much shit, but that's okay, whatever. All right. So this one, it says, here's the list of things I need to work on in 2023. And this is from her to him. And she said, 1, stop lying. 2, don't manipulate you. 3, don't throw other men in your face. 4, control my anger. Oh, I shouldn't have done that. Sorry. And don't resort to violence. Like, how in a murder trial, how is that something that's just we no sell? Okay, I'm going to do apparently something that isn't a square, or a rectangle rather. That's okay. You know what? Effectively does the same thing, but not really so much, but a little bit so much, so we're good. Oh, come on. All right. You get the point. How does that fall off the map? How does, hold on. I realized it was stupid. Yeah, hold on. How does that just totally miss everything? How do these pictures of him after she assaulted him in April, all before her death, how are these not enter? And it's my understanding, because again, I couldn't be present for all of the testimony because I was set to testify. So they didn't want me to be in the courtroom for the first portion of trial, because they don't let people do that. So James started recording like certain video, and I have some audio and some video recording, but they're more like audio where he would record their conversations, because DARVO victims, which stands for deny attack, reverse, something, something, but basically it's like where you're switching everything. Okay, I'm trying to do it, so hold on. We'll go replace there. How do we not include? Well, move this dude here. How do we include show here? How do we not include that? Like, this is after she assaulted him. She had done it in May of 2021, and there are text messages where she's inferring that. I think where a lot of people get is that, I mean, I'm willing to say that, you know, his failure to contact 911 responders was the biggest mistake he ever made, and he knows that. I think he could not believe that she just died, and he broke with reality. But she's trying to cover up his picture, his face in this one, because she realizes that he's taking photographs of her. And this is in April. This is after her arrest in February, which means she knows that she's now running the risk of being arrested for a bond violation. So we've got all of those things, and it's like, let's see, I can move this shit over here. And this is, and I was able to find her arrest mugshot, or her mugshot. And that's the other thing with how this was so disingenuously reported on, which really, really frustrates me, is that all of these people talked about how she was best friend, or that she worked for Sarah Ferguson, and that, she was a royal aide to the former Duchess of York. Well, have we seen what's happened with Sarah Ferguson lately? Sarah Ferguson needed some good PR is what Sarah Ferguson needed, okay? Sarah Ferguson did not care about any of this. She needed some good PR. And when the good PR dried out, the story dried up. And nobody did any investigation. So again, 20 years ago, her working for that woman was everywhere. But this publicly available arrest record, nobody even bothers to cover about a murder where this person was actually arrested for 7 months prior to her death. The issue where James says, yeah, it was self-defense. I'm going, why are we selling this so badly? Like, what the fuck? I mean, it frustrates me, because I don't understand why I'm the only one screaming it from the rooftops. And I know why, which is that, and I'm not going to get it's a sad case, but like, for mainstream media, this doesn't further anybody's agenda. Like, nobody wins from reporting on this. What people win is just, you really don't win much at all. And advocating for James, it has caused, really, it's just been a lot of work. And really, there's the only payoff is that, I'm hoping somebody would do it for me. It's just reciprocity in the universe and things like that. Let's see what this. Let's see. So, and just other people are being just shoved in and out of this, but let's be nice to each other. So it was just a constant back and forth. So why that wasn't included, I'm trying to find the arrest record right now. Let's see, hold on, let's see. But I'm having, let's see, I know, like, let me do this real quick. I know, I'm like showing all my shit. Hide it so much. Sorry about that. Not that there's anything really messed up on it, just a dirty desktop with a lot of stuff, because I'm going in a lot of different directions. But so my letter set that up. Okay, I wanted to show the, hold on 1 second. Too much stuff. Man, go people that can do this on the reg. Yay them. Okay, so here we go. So let's just go over, because I do want to go over some of the testimony, and I'm going to be cheap, and I'm going to use read aloud volume on Edge to help with that, because I figured, like, I haven't been, since I wasn't there with all the testimony. I know where I stand with all of this, which is that, James not calling for 911 responders, like that was problematic. And I've said that both people in this relationship, made a lot of conscious decisions to stay in that relationship. I don't think that makes abuse okay. I just think that when abuse victims isolate after a lot of time, they tend to like fall off the map. So I don't really want to like relitigate where I stand, because I think that all of the evidence really does end up saying it. So I just figured like, let's start at the beginning and go from there. But I did want to like just point out a couple of things. I mean, so her arrest record, nowhere, I'll pull that up. Nowhere in the file or in the exhibits. And I'm like, well, wait, didn't you guys explain that? And that occurred. And yeah, but I don't see it in the exhibits. Like I just did a scan of the exhibits. I don't see it. So I wanted to go over it real quick to kind of say it wasn't just like a smack. Like she punched him 8 times. Oh, let me go over that too. She punched him 8 times in the face and says, you deserved it. You deserve everything that's coming to you, which is completely in contrast. I mean, it's to her report, because she lied. I mean, she lied to the cops, and they ended up arresting her for lying because he called them, and she didn't think he was going to. She didn't think that he was going to contact them, and so she was really angry after that happened. And the other thing is that she had dangerous amounts of cocaine, methamphetamine, and cocaine in her system, and the medical examiner said that that none of her injuries alone were fatal. So what happened likely was that because she attacked him with a knife, and that's where it's always stayed. His version has never changed. But that after that, she attacked him with a knife, and that he was trying to hold her back or push her away from something, and that at some point, either pushing on her, that it ultimately caused her blood pressure to drop so quickly that it basically induced a cardiac arrhythmia, a heart issue. And so, and people go, well, that sounds like bullshit. No, she had a history of a carotid sinus syndrome, which has regarding breathing. So, and with 3 cardiotoxic substances in your system, it's very possible that could have happened. She was also on a bunch of booze, and so she was a little more surly than usual. James had said that when she was on drugs, she would get that she could get more aggressive. And so it was mutually toxic, but she was always the aggressor and initiated violence, and he tried to run, and it happened multiple times. And just this time he didn't get out fast enough. So I guess what it comes down to is that I don't think that James deserves 72 years for not dying first. And people who knew her have even told me that what was reported is it's bullshit. That she wasn't like this doe-eyed chick. Like, no, she jammed. She jammed, and she was aggressive too. And or not too, rather, but she I think there was mutual jealousy at times, but she would get mad at him for dating people when they weren't dating, which was weird to me personally. And then she would want him to call ex-girlfriends and just tear them down. And she tried to get him to do it with me once, and he was like, not doing that, because he knows me, which is that I don't take kindly to that stuff. And if you do that with me, if you do not come to a gunfight, with a knife, just don't. So this is the incident report. So this is 7 months prior to, let me share a screen, to her death. And it is, let me see, replace with this. And it shows the incident at the National. And the National, they also lied too, but that's for another one. Let's see. Which one? This is that's Edge. There we go. Okay, cool. Let's jam. So, and then I should move this thing so much. So, okay, show. So this is from, this is the case number, this is incident number. This was 2/13/23 at 4:19 a.m. And they got in and got out. I'm still waiting on the body cam. The primary offense, assault, family violence, bodily injury, only PC 22.01. And I've got pictures too, I'll show. I mean, it's not anything like, and I have the audio from that night too, because he managed to, and he does record, and you can hear her breaking things. She had basically come from San Francisco to visit him, and then I think she went through his phone or his laptop, things that you do in healthy relationships. And at some point, and he just found out. I'm not sure if he was dishonest about a girl or what, or if he was honest and it wasn't when they were, or it was a discussion about when they weren't dating. But it's the entryway, late night, 0 to 7:59. No, it's not gangs, personal weapons, hands, feet. So people are like, oh, big deal. That's why this being a standard ground case, people kind of scoff at it. At Melly, I don't know who that is, but I mean, I can dig it. What's up, at Melly? Send me. I just because I don't know how to navigate this. I would love to. I mean, I can dig it. My Twitter handle is. It's sorry, I spell it tarded. It's the number 2. I'll type it here. Okay, I'm going to say, please relay the message to Melly to reach out to me on Twitter. My handle is to be clear on there. When I'm not doing locales, I'll do that. So she punched in the complainant's right side of his face. Okay, so I mean, this is here, and I don't know how the fuck this didn't get into the exhibits. I'm going, okay, if you are saying that this person was murdered by her husband, you need to also include the fact that you need to include the information that she was a violent aggressor. If there are 2 documented incidents in this year alone, that means other stuff. And it was. She became way too comfortable with putting her hands on him. So it goes down. Cream colored dress, black shoes. Was it the National, or was it 1555? So charge, assault, family violence. On 2/13/23 around 4:29 a.m. Arrested person, Chapman. Janine struck with an open hand and punched with a closed fist complainant Patrick on the face, causing pain at their address. Family violence relationship. Arrested person Chapman and complainant Patrick have been in a dating relationship for 4 years. Narrative written by this, who did testify. This officer did. Mazda 11982. When arresting officers arrived at incident location, they met with complainant Patrick, who stated that his girlfriend, arrested person Chapman, struck complainant 6 to 7 times on the right side of his face with arrested person Chapman's open right hand, and then Chapman punched complainant Patrick once on the right side of his face with arrested person Chapman's closed right fist. Patrick states, arresting to officers that he felt pain from strike. And the thing is, let's be real, okay? Let me just get big in myself for a second. If this were a chick complaining that a dude did this to her, he would have been arrested immediately. We know this. All right. There's a stigma where people don't believe men as much and they don't give them credit. And the state tried to say that this was fabricated. The fuck it was. Here's the report. Don't pee on my leg and tell me it's raining, or as Jeremy Hambley likes to say, don't shut my mouth and call it a Sunday. But seriously, don't lie to me like that. That's ridiculous. So arresting officer Sherwood spoke with Patrick James, who elaborated on the incident. Chapman had come to Dallas to visit from California to visit complainant Patrick. I need to go back to this. To visit complainant Patrick James said that they were attempting to fix their relationship for 4 years. Fuck it, leave that shit. Okay, everybody, here's another one too. I'm saying this from personal experience. If you've left a relationship, you left it for a good reason. You weren't on the same vibrational wavelength. Leave that vibration behind. Move forward. Be better. And be better to other people. That's your mea culpa for losing that relationship. Don't go back. They made that mistake. This is a cautionary tale. This really is. So boom, boom, boom. Complainant James, I'm just going to say James. I don't like reading Patrick. I don't know why. It's just not my jam. And arrested person Chapman had gotten into a verbal altercation During this time, an arrested person, Chapman, became very agitated and started to break items in, and I've got the video that isn't on the body cam. This is separate. Like, I don't, they made the mistake of not playing this for the jury. They basically sent it back to them. And I learned when I was paralegal, you don't do that. You play everything on the record, because you can't expect the jury to go like, well, when you've gone for 11 days in trial, you can't expect them to go back there and figure out what pieces go to the puzzle. You're supposed to give them the pieces, you know. They need to be turned upside down. You don't just throw them the puzzle and go, hey, have fun. You need to tell them what's going to be built. So it goes on to say, okay, she started breaking stuff in his apartment. Complainant Patrick attempted to stop her, and that's what you'll hear. And I've got the video; I can play it, to stop Chapman. And that is when Chapman struck him 67 times on the right side of his face with Chapman's open right hand, and then Chapman punched Patrick once on the right side of his face with Chapman's closed right fist. Patrick said they attempted to talk for around an hour after the physical altercation, but eventually Patrick went down to the lobby to called 911. Maza and Ramirez went upstairs to his apartment and made contact with Chapman. Arresting officers asked multiple times what occurred tonight between her and complainant Patrick. Chapman stated multiple times that nothing had occurred and that they, Chapman and Patrick, had just gotten into a verbal argument. Ramirez asked Chapman that at any point here, I'm sorry, I should have zoomed in. I apologize. I was like, you can't read that for shit. At any time, any 1, 2, 3, 4, 5th. That's what she should have said. Don't lie though. Don't lie. 1, 2, 3, 4, 5th. Don't lie though, because if you lie, no bueno. Did the argument turn physical? She stated that it did not ever get physical, and we're going to press X it out. Based upon information received from Patrick, arresting officers determined arrested person Chapman committed the offense of assault at the following location. Injury sustained, and they arrested her for domestic violence. So this shows that, and it's the same. She struck him, and I mean, I'm like, hello. I mean, I'll play part of that. I mean, it's not anything that's egregious, but basically, this is nowhere in the court record. Okay, this is nowhere. I requested this through a public information request because I wanted to see what happened. And the thing is, the exhibit list. Let's see if this is it. The exhibits. Let me see. Come on, show me. No. Okay, those are exhibits. Let's see. So, okay. So, I guess I can start at the beginning. I've got the read aloud ready to rock just to go from the beginning. So they have all this, they have that information. Oh, and I mean, again, for anybody who is just dropping in to say hi, what's up? Oh man, of course that would happen right while I'm doing that. There was, there's a picture, pretty, fierce picture of that she had, no, go away, fuck off. This is like 2 months after this. So, I'm like going, dude, this person did not lose, they did not, and I'm thinking, again, James, it's like, did we not learn from the first time that she did this? It's like, or no, that was that time. Sorry. And no, that's not like a big deal, but that just shows what like happened around that house. Why did we forget that she had done this before? I don't know why we're all cool with that. So, I like that. I named one of these files evidence. And then they were married in June, which shows like how like kind of insane this relationship could be. And so, I've already gone over that stuff before. I thought that this was interesting today. Let me do this. Hold on. I was going through the reporter's record. Come on, dude. Come on. And I was looking at what the jury requested while they were deliberating. And I found it really interesting that they requested all of these reports, but like the information relating to the Dr. Clayton, who discussed his dissociation And oh, you know what? Fuck it. No, let's go to appeal because I'm pissed about this. So this is the other thing too. I am not happy having to be in this place because of having to effectively advocate for my friend in ways that I shouldn't have to because of the fact that his attorney um, didn't do his job. Like, I mean, and I don't even mean like kind of didn't do his job. I mean, this dude was told straight up what the puzzle was, and he didn't bother to fix it. And so I'm like, all right, well, let's go. You know, like, let's, let's talk. So, okay, let's see if this is it. 2025 sec. Okay, cool. Yeah, we got this. Holla. All right. So, what are you doing? Show the other one, you butt crust. Let's see. Come on. Replace so much, so much. That one. Yeah, please do that one. Please and thanks. Why is it doing that? It's not. It's fine. Okay, fine. Doing this. Come on, close it, buddy. Of course, not responding. Of course. So because his attorney and I provide a copy, and I'll go over his motion debate because I want to show what he said versus what I said, and then we can look at what James said in his filing because James had to file one, which sucks for him, man. I'm like, dude, and I had to help him draft it. But he had to file his own motion to debate to try to pause the proceedings because his attorney did not do any of what he was supposed to. Why is it doing this? Okay, hold on one sec. It being dumb so much. Why is it doing that? Let's see. Okay. So I told him, oh, here, let me go back to this. Hold on, sorry. I need to finish going through this email that I had sent him. It'll make more sense. Move out of the way, buddy. There we go. All right, let's replace this with this. So that it basically explains, okay, here we go. Boom. Let's finish going over this. So I wrote his attorney 3 emails, and again, didn't expect an email or a response back. Why aren't you showing my email, brother? Come on. I'll screw that up. That's all right. So pissed though. I was on a roll. I don't think I was on a roll, but that's okay. Um, so his attorney, okay, I'll say, I need to get a new webcam, but that's for another day. So I submitted to the court the amicus curiae saying, look, just no, he doesn't want to represent himself, and his attorney misrepresented to you that he wanted to represent himself pro se. And and I continue to say it, and I will say this with my chest because I think that it is malpractice. I do. I think that his attorney was either in on it or he was too stupid to notice that these issues that were preserved by objection at the trial court level for appeal, he knew about them. He did not mention them anywhere in his appellate brief, even though they were the strongest issues. And at that point, I went, this is a crooked case. It's a crooked case. So, or at least, or he's not doing his job. I mean, he's being incompetent. So I submitted this grievance, and it did result. I mean, the progress, yay, golf clap, because guess what? Who finally got part of his trial record? James finally got part of his trial record. Why? Because we bitched long enough and loud enough, and actually, it wasn't even that. It was that we finally, James filed a grievance with the state bar, and I filed a grievance with the state bar. And I usually don't like things like that, but gatekeeping is necessary so that attorneys do their jobs, and when they don't, they're held accountable. Because the scary part is that this dude, this is not the only case that he is court appointed in. And I looked in those cases in Dallas County, and he hasn't updated his notice of change of address. So if any of his clients need to reach out to him, guess what? Good luck, because they're going to be about as helpful as it's going to be bounced back. So I just wrote, okay, overview. So I submit this grievance regarding court-appointed appellate counsel Michael Casillas based on a pattern of conduct demonstrating complete failure to communicate with his indigent client, failure to maintain accurate contact information, failure to provide access to the appellate record, and material mischaracterization of client communications to the Fifth Court of Appeals. I am not the client. Why is this constitutional? What the fuck? Oh, that's all my stuff. I don't want to put this in my stuff. I want to go hide it. Not that I have anything like weird over here, but I don't know. I should show them. I shouldn't try to find out on stream, but whatever, you know. You'll live and you'll learn. So how do I do full screen? Visual screen? No. Okay. That, boom. Okay. No, I don't want that. Hold on, no, never mind. No, I don't want that. There's a reason why I don't want that. Because this one has, man, I didn't, hold on. Hold on. One sec. Oh, man, hold on. Sorry, I've got it somewhere. Just rock with me for a sec. Oh, let's see, entire screen, so much. I should probably open it, though. But basically, like, I lay this out without tinfoil hat. I'm like, no, he didn't do his fucking job. And like, and here's how he didn't do his job. And I lay it out in a way that, you know, doesn't leave anybody feeling like an idiot, and also makes it very obvious. I mean, it's very clear that this individual has lied to the court and has tried to effectively throw the case so that it can just be affirmed and he can be done with it. Well, that's not what you get to do when you are you choose to be a public defender. Sometimes you get shitty cases, and then maybe you shouldn't do that. I mean, maybe you shouldn't jam with cases where you don't get to do the fun stuff, or where you don't just get a sweet, easy $3,000 or whatever. You just, guess what? Then don't do it. Just don't do it, because otherwise, you know, I'm sorry if I'm disrupting their. I'm sorry if I'm not allowing, you know, collusion, or, and if it's not collusion, look, it's just bum work. It's just terrible work, and I'm sorry that I'm not letting it happen in real time. But my issue is that we don't do that. That play a clean hand, and if you don't, there are occasionally people like me looking out for their friends in prison, and that's exactly what I've done. So here's the first page of it. Here we go. There we go. I found it. So much. Okay. I really need to find another word, but that's okay. Until then, here we go. Okay. Here we go. Boom. All right. Holla. All right. Here we go. All right. And scene. So, okay, here we go. I submit this. Zoom in so everybody can see together. The whole class can read. I submit this grievance regarding court-appointed appellate counsel Michael Casillas based on a pattern of conduct demonstrating complete failure to communicate with his indigent client, failure to maintain accurate contact information, failure to provide access to the appellate record, and material mischaracterization of client communications to the Fifth Court of Appeals. I am not the client. My involvement has been solely at the request of James Michael Patrick to assist in relaying his concerns and preserving a written record. My communications are included only as documentation of the client's requests and counsel's lack of response. Mr. Patrick is indigent and therefore entirely dependent upon appointed counsel for communication, access to the record, and effective representation via presentation of preserved issues on appeal, except for it should entirely depend on, and me filling in the gaps for this dude. Failure to communicate with client. There has been a total breakdown in communication between respondent and his client. Hey, Dom. I'm going over the grievance right now. Sorry, I'm going over the grievance because I filed this on May 6th, and there has been some progress. His attorney actually provided him with 9 of the 11 volumes of the trial transcripts, but he still hasn't provided him with a copy of the reporter's record, which shows what the jurors asked for when they were in the deliberation room, which shows that they completely just were like, no sold. I mean, they were just like, yeah, we're not believing. Basically, it looks like they just kind of thought it was a manufactured incident in February. So, failure to communicate with the client. There's been a total breakdown in communication between respondent and his client. Mr. Patrick attempted to contact respondent regarding the contents of the appellate brief, specific preserved issues he wanted raised, and how to obtain a copy of the trial transcript. Mr. Patrick mailed at least 3 letters. At least 2 were returned to him as undeliverable. One of those letters specifically communicated Mr. Patrick's concerns that the issues respondent was arguing on appeal were not preserved at trial. Mr. Patrick wanted respondent to read the letter so that the brief could be corrected or supplemented with properly preserved issues. He would have had to file a motion to leave, which basically says, hey, court, sorry, can you ignore, my other tests? I turned it in too early. And at that point, they would have had to either have a hearing or they could grant it or deny it. But considering now the thing is, too, it would have been, for the timeline, it kind of would have screwed over the state because the state had already their deadline to submit their reply brief was about to, or their reply was coming up. So this would have screwed up the timeline. But I'm going, I don't care. That sounds like a you problem. So at Mr. Patrick's request, I emailed respondent to A, request guidance on obtaining the trial transcript, and he never responded to me. I'm thinking, okay, well, that's, at least tell me something. B, reiterate Mr. Patrick's concerns regarding preserved constitutional issues. And C, request that respondent communicate directly with his client. Respondent never responded. Additionally, as early as November 10th, 2025, Mr. Patrick explicitly requested through me that respondent register with Securus Technologies using Mr. Patrick's inmate account information so they could speak directly from prison. Respondent never registered and never utilized that option. Failure to maintain current contact information. Attorney Michael Concious has failed to maintain accurate contact information with the 5th District Court of Appeals as required by Texas Rules of Appellate Procedure 9.1 TRAP. Legal mail sent to him was returned undeliverable, including correspondence I sent on April 15, 2026. Although he has since updated his address, and he did. I think, well, it just took a bar complaint for you to do it. Good job, dickhead. And I mean, the thing is, it's like, check your people, check the people in your house. I think it's important for us to gatekeep our own so that we don't have to have government involved every 5 seconds. With them, I'm just like, I pay my taxes, fix the streets, and leave me alone. So basically, he changed his address on the State Bar website, but he has never filed a notice of change of address with the court and still has not done so as of today. He also never notified Patrick of the change. E-service errors appeared next to his name. These failures during the critical period of Patrick's direct appeal of his murder. These failures occurred during the critical period of Patrick's direct appeal of his murder conviction. Failure to provide access to the record. Mr. Patrick repeatedly requested access to the appellate record. Respondent never provided a copy of the appellate brief, a copy of the motion for abatement, access to the reporter's record or clerk's record, or any guidance on how the client could obtain the record. That's wild to me. As reflected in Mr. Patrick's own pro se motion, he was unable to review the record or verify the accuracy of the arguments made on his behalf. This prevented him from meaningfully participating in his appeal. 5. Material misrepresentation of client communications. On April 11, 2026, I sent respondent a detailed email on Mr. Patrick's behalf that explicitly conveyed Mr. Patrick's concerns and directives. That email requested that respondent seek leave to supplement the appellate brief with preserved constitutional issues and provide Mr. Patrick access to the trial transcript. I also set a firm deadline of April 14, 2026, and advised that Mr. Patrick would file a motion to abate if the breakdown in communication and denial of access to the record were not addressed. And also, let me also be clear, I sent him an email on April 6th, so it wasn't like I just gave him 3 days. So any attempt to characterize it like, well, I didn't get enough notice, bullshit. Stop it. I made sure to give everybody the emails because I pretend like 1984 was an instructional manual. We don't play. So, nevertheless, on April 14th, 2026, the exact deadline I had set, right? Wink, wink, nod, nod, right? Like, see, he's listening is my point. See, the exact date, right? Respondent filed the motion to abate for abatement without contacting Mr. Patrick and without responding to the April 11th email. I didn't expect him to, but but the point that he filed it means he read what I sent him. That's the part that matters. But with that one, you've got to kind of come to your conclusion, and I lead them through the I lead them through the fields, but I didn't want to come off like an ass. I figured that that's pretty clear. In that motion, respondent represented to the court that he had received correspondence indicating that Mr. Patrick, quote unquote, was willing to advance arguments on his behalf. This is a material misrepresentation. The underlying communications, as attached as exhibits to my supplemental amicus curiae letter, reflect only requests for access to the trial record and for counsel to supplement the appellate brief with preserved constitutional issues, not any request to waive counsel or proceed pro se. The discrepancy is apparent from the documents themselves. Mr. Patrick's subsequent pro se motion filed April 20th, 2026 confirms this. It requests that only a hearing to determine the status of legal representation and access to the record, not self-representation. As a direct result of this misrepresentation, the court's order of April 15th, 2026, Exhibit D, addressed and denied a request for self-representation that Mr. Patrick never made. And that's something. Or as Monograph would say, what does he say? What does he always say about it? Would you look at that? I don't know. I got to watch Medicare again and remember what he says. I guess page 2. Okay. All right. So let's go to page 3. Okay. The court was never presented with the actual issues. The total breakdown in communication and denial of access to the appellate record. Basically, he was just trying to cover his own ass. Transcript excerpts provided to demonstrate preservation. Attached transcript excerpts are provided solely to demonstrate that the issues Mr. Patrick specifically identified were raised, litigated, and ruled upon at trial, and are therefore preserved for appellate review. They are not submitted to argue the merits. Impact on appeal. Despite the ongoing total breakdown, including the returned letter in which Mr. Patrick warned respondent that the issues being argued were not preserved, respondent proceeded to file the appellant's brief without briefing the preserved constitutional issues Mr. Patrick identified, visible shackling in front of the jury and jury misconduct. At the same time, the state's brief explicitly argues that several issues respondent did raise were not preserved for appellate review. See state's brief excerpts at pages 29, 33, and 35. Respondent's failure to communicate with his client and provide access to the record prevented Mr. Patrick from verifying what issues were raised, confirming preservation, and participating in decisions that affected his appeal. Pattern of conduct. Taken together, respondent's conduct reflects a pattern of failure to communicate with client, failure to maintain accurate contact information, failure to provide access to the appellate record, failure to act on client-identified preserved issues, and material mischaracterization of client communications to the court. Rule violations. This conduct appears to violate the following Texas disciplinary rules of professional conduct. Rule 1.01, competent and diligent representation. Rule 1.02, scope and objectives of representation. Failure to reasonably consult with the client regarding the objectives of the appeal and the issues to be presented, despite the client identifying specific preserved issues and requesting that they be addressed. 1.03, communication 1.16, subsection D, declining or terminating representation. Failure to deliver papers on and property to the client. And some people argue it's like that's a strike. I don't think it is at this point. I mean, you give your client a copy of his trial transcript. There's no other way to go about it. So Rule 3.03, candor to the court. I'm going, this is the big one. Yeah, now you got a liar in the ranks. Have fun. The discrepancy between respondent's motion and the underlying communications, combined with the timing of the April 11th, 2026 communication and April 14th, 2026 filing, raises concerns regarding whether a false statement of material fact was made to the court. I should have entered over. What can you do? Rule 8.04, subsection A, subpart 3. misconduct, conduct involving dishonesty, fraud, deceit, or misrepresentation, and I will stand by that till the day I die. Trap 9.1, failure to notify the fifth, I should have said the Fifth Court of Appeals, of change of address causing undeliverable mail and e-service errors. Conclusion. Despite recently updating his address, Mr. Casillas has still not notified the Court of Appeals or his client, leaving him out of compliance. These were not minor oversights, but clear constitutional errors that he was notified of and he chose to ignore. Instead of addressing these preserved issues, such as the improper shackling of Mr. Patrick in front of the jury, he argued issues that were not preserved for the record. As a former assistant district attorney, it is alarming that he neglected to raise these critical preserved issues, which are fundamental to Mr. Patrick's defense. The gravity of these failures is amplified by the fact that Mr. Patrick faces a 72-year prison sentence, making the need for competent, effective representation all the more critical. Karen, a period is critical there. Respondents' actions effectively exclude Mr. Patrick from meaningful participation in his own appeal during a critical stage of the proceedings. I respectfully request that the State Bar of Texas investigate this matter. Respectfully submitted me. And guess what? They did. That they did contact his attorney, and his attorney supplied a letter with nine of the volumes to the warden, with basically apologizing, for lack of a better term, saying that he was ordered by the State Bar, which means this is being investigated. So here's the problem, though, and I'll go to it. And this is kind of where we're at, because I'm going to go over all the trial transcripts. Like we're doing that, not all night, because I mean it was an 11-day trial, plus the dates of deliberation, whatnot. I think it was like 13 days. I don't recall how. I think that they had ended up only. They did not. And let me find that, because that should. I'm like, are you kidding me? They only asked for. Oh, hold on, you're right there so much. And she locked his phone. I mean, the things, I've got all these photos, and I mean, I've got copies of all this stuff. I haven't had an opportunity to go through all of the exhibits yet to see what's in there, but I have seen that they're like the arrest record I went over earlier. That's not in there. I'm like, why the fuck isn't that in there? Why did we decide not to call the officers who arrested her? I mean, why was I cut from the list of people? Because I had sent him an email 2 days prior to Janine's death. And I said in it very clearly, I said, you both are just nuttier than squirrel shit, and just keep it away from the rest of us who just don't want to fuck with it, and you're willing your destruction into the universe. And I didn't mean to say it in a soothsayer fashion. It was just that both of them were so toxic. So I'm trying to get this to a place, and I'm trying to get, eyes on it and attention on this case, because I think it is something that does need to be looked at. I think that the state absolutely, and they did during their closing, it had to be objected to. They started, they held up a picture of her after and I'm not saying like it was smart. I mean, he should have called 911. He was freaked out that she had died, and he was a tar. I mean, that's my take on it. But again, there is so much evidence that shows that she was the aggressor just physically, and that it happened more. I mean, it happened twice that year. And I remember when he called me in May of 2021. Oh, and there was DNA that was not, that the state had from a third party. And they just were like, this is inapplicable. Why don't you let the finders of fact determine that, since you're so intent on curating this just perfectly and omitting certain things so that it misrepresents it intentionally? Like, just stop it. And she had to be corrected. The jurors were heard discussing this after, only 3 days of it. And the defense hadn't even put on their case in chief yet. So I'm going, why? Like, I'm just perplexed at the fact that all of this happened. Let me pull up Edge, because you can see it's very clear, and it's kind of like, it's kind of alarming. Like, let me see if I can do it here. Here. That when you look at the things that they requested, and I'll go through it with you to see, where is it so much? Let's see, we're on the record. Oh, here we go. Here, this is the jury. Yeah, this is the jury misconduct. Let's go through this real quick. I'll do this with read aloud. Hold on, let's see. So much. Everybody. Okay, here we go. Okay. And so this is, and so mind you, it says at the top of this, here, let me share this. I'm going to do this. I'm going to share this. Let's see the screen. Okay. This is this is trial day 5. So, I mean, we're there halfway through the trial. But at that point, the thing is, if I'm running this trial, I don't want this to be overturned, or I don't want this to be reversed. Like, I don't want to see this shit again. So guess what? Take care of it right the first time. Okay, so why are we talking about this issue? Well, because they had alternate jurors. This juror was discussing it, and the result was an admonishment. For an issue like this, you don't do an admonishment, okay? You fucking bounce that person, period. You have alternates, you use the alternates. So here we go. So let's look at this. Jury trial day 5. And it cost me about $350 of my own money. Thank you, City of Dallas, for making it incredibly difficult. Really appreciate it. They will not tell you. I mean, getting to this, I finally was able to through just banging on the I call it Court of Appeals. They were much better. City of Dallas sucks. I'm not City of Dallas. I mean, just the I know that they're overworked after COVID. My heart goes out to them, and also nobody is there. I mean, people are just not there. Everybody's leaving on Thursday when they haven't gotten to the next day. It's a shame. How do I do this? Okay. So it's the court. I'm trying to get to a point where I can read it. The streamer wants to collab with you. I would love to. Yeah. No. I'll hit him up. Let's see. Let's see. I'm doing. A TFR. Okay. So it's the court. They say, we are on the record. Let the record reflect that defendant is present with his attorneys, the state is present, or outside of the presence of the jury. However, juror number 4, Miss Allison something, is before us. And Miss, the reason I call you in this morning is some information got to me regarding discussions you were having. Let's see, that you were making comments about the defense's cross-examination, particularly regarding the cardiac arrhythmia, that you made comments that were kind of laughing at the cross-examination and the defendant's theory, that you were talking to other jurors, and that another gentleman was close by, could hear that. So is that accurate? Were you making that? Were you making comments about that? Juror number 4. I mean, I think there was some kind of discussion yesterday around that introduction of the cardiac idea, but certainly I would not laugh at it. So look, so she just said yes. So she just said yes. I did talk about that I did talk about that outside of the courtroom, even though you told all of us not to talk about this until it went to deliberation. So she's admitting to this, and then and it continues to go on. So she's saying, yeah, but I didn't laugh. Well, I don't give a fuck if you didn't laugh, okay? You were talking about it. That's the concern, yes? And the fact that this that Judge Chica Enium, that she didn't ride this harder is outrageous to me. It's outrageous to me, and it makes me angry, because I would the thing is that you got to check people. Otherwise, I mean, we're just pissing up a rope, and then you allow the Jerry McHambleys of the world and just everybody else to try to change the narrative. And the fact is that, that there are people that are doing their best to make sure that the truth comes out. Lucy Sleuth, like, I got to correct her ass too on YouTube. And Lucy, I'm coming for you too. I'm going to be correcting you too, because you don't get to make false statements about somebody and think that you're not going to correct it when you're given information that tells you straight up that he wasn't arrested for domestic terrorism, that this other James Patrick was arrested. And it's very, very easy. You can find it on benverified.com. Give me a break, dude. If I can find it, man, trust me, I can show you how to find it too. So she goes that she wasn't. So were you making comments? She goes, but I certainly wouldn't laugh at it. I mean, I take this very seriously and feel a very heavy responsibility. Well, you should have felt a heavier responsibility by honoring your oath to not discuss it outside of the courtroom, and hold on to getting any ideas until you heard everything. So the court, okay, so who was doing the discussion? Who was all talking? I honestly don't recall. I'm sure you don't. But you're telling the court you didn't make any comments about it. Juror 4. I think we did. I think there was a little bit of discussion, just sort of a conversation that never evolved about cardiac. So I may have said something, but I certainly would not be laughing about it. Oh, you're just concerned about how people perceive you. You're such a snake in the grass, dude. The court. Are you talking in the jury room or while y'all were leaving for the day? Because this incident that I'm talking about, you're telling me about discussing in the jury room. Juror number 4, yes. But the court, but I'm talking about you were released for the day while the jurors were released for the day and exiting the building. Juror number 4, oh, I don't think I recall that. No, because we were walking all around because the doors were locked. It was kind of a lot getting out. The court, there was confusion about how to get out of the building, right? Well, there you go. That's why he was convicted. Dude, you gotta be advised, most people's IQ has actually gone down by 10 points worldwide. No joke. It's actually at, I believe, a 90 now, and they've had to do a they've had to move everything around to basically make the cattle dumb but not be looking dumb. It's really retarded. The court, there was confusion about how to get out of the building. Juror number 4, yes, because when we got at the door to the tunnel, it had a sign that said we couldn't go out that way, so we all got there and had to go back upstairs. The court, interesting. The bailiff will sort that out. Juror number 4, and it was fine. We just had to go out the front door. But I mean, I think there was just general conversation as we were leaving. The court, okay, every day I have talked about that the court's instruction not to discuss testimony and that this is exactly the type of discussion or commentary we're talking about. You can't comment on it, discuss it with each other or anybody else because you haven't heard all the testimony. The juror number 5, understood. Yeah, I'm going, well, I don't think you did understand. The court, because when that happens, it gives the impression that some of you have already made up your minds, what they think is going to happen. And guess what? That's pretty much what we see with what they requested to look at in the jury room. That's pretty much what we see. And then you add on top of this that later on in 4 days, James gets shackled in front of the jury. Are you fucking kidding me? This is ridiculous that this was allowed to happen. And also then that's ridiculous testimony too, because you see that a piece of wood was put in front of his shackles and that he wasn't going to be able to stand up for the jury to give them respect. And I'm like, dude, that's a little sussy, Understood. The court, because when that happens, because it gives the impression some of you have already made up your minds. It sure does. What they think is going to happen. So you couple that too, and that's the problem too. You couple that with it gives the impression that some of you have already made up your minds. You add that to the fact that he was shackled later, which again is prejudicial which is not permitted because it is deemed to be prejudicial on its face. So you combine these two things, and yeah, I do think that he needs a new trial because he wasn't given a fair shake. Juror number 4, I see. Oh, I'm sure you do, bitch. I'm sure you do. I'm sure you do, Allie. The court. So if anybody is discussing anything of the testimony so far, I need to know about it. And she's not going to rattle him because she knows better. And somebody brought that to my attention. So that's why I'm addressing you because, my impression was that you were the one doing the talking. So you're saying it was not you. Juror number 4. I mean, I'm not saying that I did not talk about the cardiac incident. I think there was certainly conversation around it yesterday. I would never laugh or not take it seriously. Why do you keep going back to laughing? Like that seems to be her main concern. I'm like, whatever, dude, the court. But you understand how such discussions aren't allowed, period, until you are all deliberating, until I've instructed you to deliberate. Jury number 4, yes. The court, okay, so does either side have any questions for Ms. Zolnick? Ms. Mitchell, none from the state. I'm sure you don't. Yeah, you want to keep her on. Mr. Clancy, none from the defense. The court, thank you very much. Juror number 4 exited the courtroom. The court, so it appears that I will admonish the entire panel. Mr. Clancy, so this is James's attorney. Yes, Your Honor. And just for the record, we respectfully ask this juror be removed and an alternate be replaced. That would be the first request. And if that request is denied, we would also, again, for the record, respectfully request a mistrial. The court, what's the state's response? Ms. Mitchell, I believe an admonishment is man, Ms. Mitchell, Ms. Mitchell, if you ever see this, I've got some thoughts about you. I wish you $1 million and an improvement in your moral compass. Which at 50, 55. Oh no, you were probably 50 or something. That's probably a tall order, but when you're climbing the ranks, and you gotta lick some boots and gotta crack some eggs to make that omelet, right, homie? You're not my homie. Just kidding. So she goes, she thinks that that's appropriate. I believe it's something that's on the record, and is on the record and we'll take care of it. I do not think there needs to be an alternate in this. They are human. Oh, please, whatever. If the shoe were on the other foot, you would be saying something different. Don't even. And she talked mad shit about me too. And I was like, dude, and I'm like, well, call me up. Let me talk. But they didn't. I'm like, okay, well, but so no, I'm correcting this. If I have to correct it after the fact, I will continue to do it. Because I don't like my name being drawn out, misrepresented. And then I'm going to show you after this the motion to debate where it says that James wanted to self-represent, because I'm pissed about that, because it's just not true. And I'm thinking all of you, I mean, just how they curate stuff, be advised, the state is not your friend, okay? They are not looking to make things easier for you. If you're ever in the criminal justice system, they are looking to wear you down. So many people have spoken on this. It's, much like hatred of Jeremy Hambley in the quartering brings the internet together. The agreement is the state does not look to make this easier for you. They're human. They're put back there. We are 4 days into testimony, right? It's an intense trial. So I don't think it's out of the realm. And they understand what they need to do. You had alternates, though. You should have used them to maintain neutrality. She certainly sounded like she does not want it. She does want to take this seriously. She is taking it seriously. How do you know? You don't know the operation of her mind. Shut up. And does not want to, and does want to take it seriously. And I believe with the admonishment, they will, we're getting to the end of this trial. Oh, well, you mean your trial? And I think that what you said to her and her response to you, we will not have the same issue again. This is such bureaucrat. This is just such bureaucracy. I mean, I can just see them weaving it together and looking at each other. ESP going like, was that convincing enough, Judge? Did you hear me on that one? Did I say it right? Was that good? Was that convincing enough? She totally believed you. Did I say with enough intensity? Yeah. Just send me a wink if I need to say something else. Okay? No? Okay. I'm trying to move it. There goes, okay. So we go back to this. So court, thank you. And the alternates. I mean, this particular juror gave information that there was also discussion in the jury room about that. So the alternates would be part of that and would have heard it. So substituting an alternate this time, I'm not going to. Well, then do a mistrial. Then do a fucking mistrial. Then why? Chica, okay, come on. Wake up, girl. Wake up. Chica, are you not looking for federal? I mean, is your ceiling, is the ceiling trial court? Is that what you aspire to be? A trial court judge for the rest of your life? Girl, you have no aspiration. So mediocrity is bureaucracy's middle name. Subpar is actually, mediocrity is for federal. So so it's not going to make a difference. I believe admonishment will suffice. Of course you do. So Mr. Clancy, yes, ma'am. Can I just get on the record? You're ruling on our request both for an alternate, and I think you just spoke to your denying that request, a request for the mistrial. That is denied, Your Honor. May we bring the people back in the courtroom? I know you like the jury up. Yes, back on the record. It appears that from the discussion outside that was off the record when your wife was speaking, it appears she did say that jurors were making those comments, or this particular jury said, well, I guess they will just have the chance to call their own expert, which tells me that they are waiting to listen. Mr. Clancy, thank you, Your Honor. The court, and consider what else. Thank you. And then Mr. Clancy, thank you, Your Honor. The court, off the record, the jury entered the courtroom. The court, we're on the record. Let the record reflect the defendant is present with his attorneys. The state is present. The jurors are present and seated. Good morning, ladies and gentlemen. Good morning. The court. Thank you all so much for arriving early. Y'all are not playing at all, or maybe you're just trying to get going so we can enjoy the long weekend. But anyway, thank you for your patience. We had to take care of some logistical issues, and I want to talk to you again before we resume about my ruling. My instructions. Information came to me that some of you were discussing testimony yesterday in the jury room, and I know, it is hard not to do. Why would you co-sign on that? You are human. Stop it. You're picking her bullet points. Jesus God, man, this shit is it's just, come on, come up with your own. You want to talk about what you've heard so far and all that, but you can't, okay? You can't, because the tendency is for you to, try to make up your mind already. You have to wait. Didn't they train you in judge school about this, right? Didn't they teach you like this soliloquy to be a little stronger? I'm not buying it, man. I'm not buying it. You have to wait until you hear all the testimony, okay, from each side. And they're going, sure, Jan, it's like, come on. The defense has indicated it will put on evidence. The defendant will testify. So you have to wait until you hear from both sides before you start deliberating. Remember, you don't deliberate until I give you instructions to do so. Well, apparently your instructions were not heard, ma'am. So until then, you can't discuss with each other or amongst yourselves what you think the testimony is showing, or whether you think it has weight or not. Don't ascribe, any preferences as of yet, okay, because it could lead to a mistrial. Oh, kind of like the whole the shackling of James after this that you did, like 5 days later, to make him look like a flight risk, like kind of that, really. And this is what day four of the trial. So please do not discuss it with each other, and so on. So the point is that this case is like that. That's one thing. So his attorney just didn't even bring that up in his appellate brief. Let me see if I've got that. I do. Okay, that's exactly what the court gave me. All right, I've got my subpoint. Oh, get off the screen so much. Let me do this one. Let me do this. Hide so much. So, okay, whatever. Students thing. So again, my issue with this, well, I mean, it's a Dallas side issue too. I mean, Dallas has grown quite a bit since, especially the pandemic. I think, I mean, I forget if it was Benjamin Franklin or Thomas Jefferson or which dude with white hair it was that said that it would be better to let 100 guilty men free than imprison one innocent man. And I'm not saying, I am saying that for the purposes of for self-defense, James is innocent. He had a right to be there. He defended himself, and she tragically died. But her death was brought on by her basically by being on so many drugs that when her blood pressure dropped, she had a cardiac arrhythmia because the injuries alone were not fatal. She wasn't strangled to death. She wasn't stabbed to death. She wasn't shot to death. She didn't die of blunt force trauma. The medical examiner testified to that, but it was a cascade of events. And I think that that's why the medical examiner was comfortable enough to allude to that, but was able to say that that she did not die of her injuries. My computer's freezing up, so maybe that's the universe saying, take a hint, kid. I'm going to close these out. I can always close out some things. So I was going to look at her sister's testimony because she did testify to something, and it looks like she was not being honest. And she kind of changed her testimony on the fly because she said that there was something that was told to her that it was the first time that she was telling Mr. Clancy, this. So, and that is problematic because when people go to testify, or when people are set to testify, you're supposed to provide the other side with kind of not a total road, but just kind of generally what they're going to speak about. And when Janine's sister testified, she stated that Janine had told her that he had threatened her before. But again, what the problem with all of this is it does not line up with the text messages too, and her cadence, just her tone with James. She was domineering, and dominant. I mean, she was definitely the alpha in that relationship. That's what the impression I get when I read text messages from her. But she really has no problem defending herself and saying very, very, what do you call it? Without fear, that don't play with me, and that she didn't have time for this, and she's gonna, go do other things. But I know, right? And let's see. PSI, yeah, it's like, I mean, I'm just like, she always threw dudes in her face too, or he did, and it probably did have to do with his ego, but either way, okay, let's see. You want to defend her, okay, your best friend. She'll be thrown out on the street, try me. So it's like, I mean, this is another one where she's outwardly, she's being aggressive with him. I'm like, I don't see how this is not just a trend of behavior to show. I don't think intent was proven by the state. And I think that there was a trend of her behavior that was very clear that she could stand up for herself just fine. And he wasn't abusive. Nothing happened. Your friends take action because they have nothing to lose. No, some people take action because they see a big bully and they don't want them to keep bullying. You need to put a fucking leash on your friends and stop coming for me. Allison is an idiot. I don't give a fuck. You want to defend her. I don't care. Be her best friend. And she steps foot in the building, she'll be thrown in the street. Try me. So, I mean, she had no issue sticking up for herself or playing or getting dirty, or for lack of a better term, or starting arguments. So, and this is just, I've got a lot of screenshots with this same same energy, where it's like, try me, or you thought you were going to do nothing, or you were going to do that and get away with it. Who do you think you are? And it's just really kind of weird to me that this just that none of this mattered to the jurors. And unfortunately, just James, their relationship, it hit all sorts of people, and they couldn't stick up for him, because you can't it's hard, it's nearly impossible to advocate for somebody. Well, it's not impossible, but it's very difficult to advocate for somebody who won't advocate for themselves when they're getting punched in the face in April and getting married in June. So I think another kind of subtopic about this, and I think I want to start a Substack on this because I've been talking about it and thinking about it, that it goes to a bigger conversation about about domestic violence, and the fact that men are regularly the victims of domestic violence. James was. But this picture, let me find it again just for the purposes of illustrating my point. Let's see, where are we so much? That this happens to a dude. She ends up dead 2 months later, or 7 months later, rather. And this doesn't seem to be of consequence. This doesn't seem to be an issue, and she's actively trying to hide his face and his injuries in this photo. And this is before this. Then this is in April, and her arrest was in February. So, and I have a big problem with it, because if the roles were reversed, if this were a female and if she were male in this picture, that we would be having very different conversations, and that we would say that's wrong, yada yada. And we're not. And the fact is, he's being told that this stuff is fabricated. That's not fabricated. This isn't fabricated, okay? Some of the stuff written in articles about it has been fabricated. That is not. So I want to be very clear with that. Just that James, and he's not didn't do nothing. Like, I'm not saying like in their relationship they were mutually toxic, but he was a bougie prick in his own way. But not to the point where it constitutes harming another person or physically laying your hands on. So I just kind of wanted to go over that. And I guess, let me see, where is that? Where is my trial? And then this shows, she locked his phone to get him to come home, and he took a picture of that screen to show that it had been locked out. Now he should have waited to go to the phone carrier, but he didn't. So he went home because he wanted to talk to her, because he wanted to calm her down. He didn't want to lose. He was starting a job for as a marketing director, or in some sort of capacity marketing. But he was also going to be DJing, because he used to spin records, because that's how I knew him up for years in the scene. He had known that my brother was a house DJ, and so we started talking about me, and that's how we started to kick it. For we were friends for 10 years. We've been friends for like 10 years. So he was going to be working like just for fun but to get paid too, but spinning at this. I think it was in the National. I forget exactly, but the point is that she had told him that night. And I'm trying to find the text, because I converted all of them so that I could find it. But he said to her, or she had said to him in the text, your white privilege ends tonight. And he thought that she meant that she was going to try to get him fired, since she was angry at him for having divulged to me that she had been arrested for domestic violence in February, because then I contacted her employee to red flag them so that they could make more informed decisions about who they were going to jam with, and also because she lied on her application. Don't lie. That's like the rule to this one. Like, don't lie and you'll be square. Just, thou shalt not steal. Like, don't bear false witness. I mean, basic stuff. And she was angry at him. Basically, it's like, you didn't keep my secret. Like, well, don't be hidden, people. Like, I mean, it's kind of easy, dude. But I mean, again, what do I know? I'm trying to find it. Oh, that was that other one. But so point is, he thought that, like, but, and I mean, and I get it. I mean, I think that it's problematic. I mean, not problematic, but it's like, you've been with somebody who has attacked you before. Like, don't put it, don't think they're above, like, attacking you again. They totally will. I mean, history is a pretty good indicator of future. It doesn't determine it, but it's a pretty good indicator. So I'm trying to find it. And the other thing is too, so his attorney, I did a search of his appellate briefs, and his appellate briefs for other cases, I used the software where I compared the arguments in 2 other murder cases that he wrote around the same time. Portions of his argument for 2 of the other, or those other 2 defendants, were about 98% word for word taken from each other. So basically, he just copied and pasted issues that he thought he could get away with arguing into cases, and didn't completely look at the record. In those cases, same shit happens. It goes, those weren't preserved for record. So I don't know. I'm a little teed off at this point, and that is why I filed my complaint with the agreement with the state bar. I'm like, you need to look at this dude, red flag him, so that other people know that whether or not they want to fuck with them. And this needs to be a public admonishment, because his falsifying shit that I said, not cool. Let's look at his motion to abate. That's what I want to show. Because this dude, very clearly, I'm like, did I say that anywhere? Please, did I say that anywhere? I did not, fucker. And I really don't appreciate when people take liberties with things I said when it directly affects a really serious outcome. So at this point, where are we? So James filed a motion to abate deposit. The court denied that. He filed a motion to reconsider. The court is sitting on that. A good reason why. Oh, let's look at his attorney's bang up SIR reply to the state. So this is how committed he is as his court-appointed attorney. He decided to file this on the same day that James filed his the motion to reconsider, and you'll see something interesting on the page. Let's go to that one. Motion to reconsider. Boom, boom, boom. It's 106. Okay, right. So let's do a reply brief. Let's look at your fucking terrible job. Let's look at this. Let's show the class. Minimize this so much. No, minimize all those. Don't collapse. Whatever, no, close that. Boom. Okay, no, not that. Okay. Okay, here we go. Because this is just to show the care that was given. And by care, I mean absolutely not. So, okay, we're like, okay, fine, whatever. Yeah, what? Looks like a bunch of like. So he doesn't. So the state had replied, and I'm not going to go through all of it, but basically said, yeah, you argued a bunch of stuff, but like, it's not. So look at this shit. Look. Right there. So here, he doesn't even finish his citations. Do you see this shit? Do you see this? Citations are not even complete. What in the ever-living God are we talking about? This right here, that's fucking malpractice. I mean, well, maybe not that, but that, I mean, that's an oversight. So at least I'm not saying it's malpractice to forget a citation. I think the fact that he put that, well, at least we know how the sausage is made. Thank you. Thank you for showing us. Thank you for finally dropping the mask so we can know exactly who you are, dude, and what side you're fighting for, which is that you are looking to, you're looking to just throw a bunch of stuff on the wall that argues, okay, the certain matters raised by Appellee's response brief to be addressed. I mean, it's just a word salad, a word mashup, or it's just a 35 word car pileup. It's just ridiculous. So let's see. Appellee's responsive sufficiency arguments fail to account for how the state's expert medical examiner's testimony regarding the potential mechanism of death failed to show that a preferred mechanism was any more probable than appellate's proffered alternative mechanism of death. By having failed to have the expert provide a likelihood of the state's preferred mechanism relative to the likelihood of the appellant's, I mean, like, shut up. Like, you lost me, like, 3 words in, or no, about 7. Burden of proof. I mean, that's all okay, cool. Miss citation. Good job. Let's count how many miss citations are in this. This guy is just begging to be a judge in the future or something. I'm kidding. He's not. He's begging to be mediocre and get away with it. So 1 citation missed. Okay, let's keep going. 2 citations missed. Okay. And now I want to cross-reference all these. I'm going to check them because I don't trust anything this dude's in. So cool. So he missed 2 of 3 that he cited. Right here. Look at this. What's this? Oh, brief. What's that? Oh, what are those words? Draft 4 on a reply brief. On a fucking reply brief. He left draft 4. What dedication, Mr. Casillas. You did so good. And he had changed his address. What's this? Oh, let's look at this. What's the status? Error. You know what that means? That means there's automatic certificate of e-service. That's a problem. That means that it's not perfected. You have to make sure everybody gets it. So this dude wasn't. I hereby certify that no later than May 7th, a true, has been served, blah, blah. Additionally, I hereby certify that no later than May 30th, a copy of the instant appellate's reply brief was served on appellant. Dude, this shit hasn't even happened. You can't certify shit it's like, I promise I'll do it. I promise I'll do it. Like, no, like, do your fucking job. And then we don't have to worry about all this. So that's what this really pisses me off. So that is the reply. So that was the reply brief. Let me go to his motion to abate where he lies and says that James requested to self-represent, which again, you see very clearly in my filing that that is nowhere. James never requested that, so stop it, So that's kind of the rundown of that. I was going to go through sister's testimony. I was going to go to the bathroom real quick and come right back. Let me see if I can find something I'll find a video to play while I'm gone, just to kind of give a feeling of, or a sense of the dynamic of the relationship, let's just say. And I actually need to work on editing these down and cutting them for a packet to the parole board. Because the thing is that if you can show them sufficient information that so the sentencing and the deliberation phase for guilt or innocence are 2 different kind of beasts in Texas. One with the punishment phase, you can kind of pivot, and for people, their brains don't wrap around that. I mean, for me, it's hard for me to understand. I'm going, what? So you're trying to tell me that you argued self-defense like for this entire trial, and now you're trying to tell me that sudden passion, huh? So it's kind of just both those things at once. It's hard for them to wrap their head around, and I don't blame them. I think that that's something that needs to maybe be explained better to them. I'm going to go to, where is it so much? And getting attention on this case has been very hard. I've contacted the National Coalition for Men. They are completely operated through volunteer efforts, and they don't have the resources to run anything on this. I'm going to try to write some articles on Substack and see if they would be willing to post them and provide a copy of this. I need to change the Give, Send, Go. I'm still trying to pull together money for a criminal appellate attorney, but honestly, I spoke with a firm out in Abilene, and mean, they wanted 15,000 for an investigation. I'm like, dude, I got the investigation. I got all their stuff. Like, we don't need an investigation. We need a good appellate brief. And so that's what I'm trying to think of is like, okay, well, if theoretically Casillas does get removed, what's the next step? I mean, my concern is that I don't want them to make James responsible for his own brief. I mean, when he doesn't have a typewriter, I mean, he does have some law library, but I mean, he doesn't have a complete record, and he doesn't have it. He can't just do searches and stuff. They don't have computers there. So let's see. Let's do the shackling and water issue just for anybody who hasn't heard it, because this shit's wild. Like this, I was like, okay, we're put a fork in me. I'm done. Like this is wild that this happened on the record, and nobody seemed to like say anything. And I'm thinking, isn't that like pretty basic? So I'll look up the. Well, stop it. Okay, let's see. Okay, let's do that. So I'm just going over Duckby, Missouri. Okay, here we go. I'm just trying to find something while my computer freezes up and stuff. You know, all the good things. And it might not do it for me. Come on, buddy. Let's see. Oh, yelling, so don't do it so much. Just kidding. You do whatever you want that much. Let's see. Hide that. Okay, cool. Yeah. I got all your stuff. Oh, I need to go through this one. Man. Okay. So the Duckby, Missouri, it was a United States Supreme Court case that dealt with the constitutionality of shackling a prisoner during the sentencing phase of a trial. But it's also about just shackling in general is the thing. In a 7-2 opinion delivered by Justice Breyer, the court held that it is against due process, a right prescribed by the 5th and 14th Amendments, to shackle a defendant in the sentencing portion of a trial unless the shackling relates to a specific defendant and certain state interests. The issue is that it wasn't even that. He was shackled during his testimony, like in his own defense. So imagine if you saw that. If you saw a defendant, he was unshackled for 2 days, standing up when he came in the courtroom, all the things you're supposed to do, show respect, yada yada. And then suddenly they're sitting down and shackled. Now, why is that, bailiff? Did you do something while we weren't here? Is he a danger? Did you find something in his cell? What's going on? They can't tell you. They're not going to say anything. So you're left to kind of infer, because that's what we're trying to put the pieces together. And so they didn't know. And the thing is, and we can't know for sure whether or not they saw it. But the sheer fact that it was discussed on the record in the way, and it was not elaborated on specifically regarding what they were going to use to conceal his shackles, besides a quote unquote piece of wood, literally that's in here. I'm trying to pull it up. I'm gobsmacked. I mean, I'm absolutely floored that this was allowed to go, or to be so general in the trial record, about something that, I mean, it really can affect the outcome. And I mean, I can't help but think it did. Of course, you know, I've got my inclination to back my friend. So I'm trying to get to, okay, let's do this. Let's do this. Give me so much. Come on, buddy. So what has everybody got going on this weekend? That was a joke. Sorry. If you know, you know. If you don't, you're better for it. Okay, appeal. So, where is that? Why is it so much? Okay, boom. What was I going for? Oh, right, the shackling. Yeah, this shit's great. All I gotta say is, if you are ever in a jam, don't do it in Dallas. Dallas is corrupt. I'm not saying they're all in on it, but I mean, let's put it this way. They are willing to make some, what do you call them? I can't think of the word. I guess I'm getting tired. Concessions for their own people, but they will hold your feet to the fire about everything, including, are you sure that you're wearing your Tuesday panties? And if you're wearing Wednesday, then expect to be grilled about it on the stand and not get any grace from them. But then they expect all the grace in the world. Fuck off. Like, I'm not about it. The double standard, and just fuck right off. I'm not about it. If you're gonna you live by the sword, you die by the sword. Do it right or don't do it at all. And don't do it wrong and expect people like me to find it and go like, hey, here's an issue. And y'all be like, and be okay with this. So point is, let's see, let me find it. Oh, come on. Okay. Come on. Okay, shackle blood test. Oh no, that was it. No, never mind. Just kidding. That was volume. This one. Let's see. Day. Okay, I think this is it. All right, let's go. Fire con Dios! Okay, so this is not January 23, 2025. And I am about to sneeze, so give me a second. Hold on. Maybe I'm not. Let's see. Stare into the light. What? Oh, it's on the cusp. Man, okay, now it's going away. Oh, I hate that. Oh, man. Hold on, let me see if I can get it out. Oh, no, it's not going to work. Fuck. All right, that's okay. Whatever. It is what it is. So let's see. All right. So, ooh, nice. Assassination City. Nice. Roller derby. I wish that I was still in good mood or good. I could take a beating like I could in that. Okay. Yeah. All that stuff. Okay, cool. Oh, yeah, cool. All right. We already did that. The cat doesn't have a chip. That's the other thing. I had to found a dead cat and they were hit by a car and I had to was trying to find its owner and it was horrible and wasn't able to. So just trying to help things get home and it just doesn't feel complete when it doesn't happen. So let's look. All right. Share that. Okay. Okay, let's do that. Boom. Boom. I wish we could do. Okay, well, whatever. I can't. So there we go. Yeah. So this is from January 23rd, open court. Okay. Oh, can I do that? Yeah. All right, yeah. I can get some meat. Nope. Okay, well, this is the page that actually. So we go through the song and dance and the part that is relevant is I'll get to it. So Mr. Clancy, his attorney, says, "Yes, Your Honor, we've come in this." It says, "Defense counsel has an issue for me." Oh, do we, ma'am? Mr. Clancy, "Yes, Your Honor, we've come in this morning and of course let the record reflect that Mr. Patrick is on the witness stand. We just finished, I believe, it's a 7-hour direct examination. The entire time Mr. Patrick was on the witness stand for 2 days in a row, he did not have leg irons, shackles. He was not shackled, and we came in this morning, and your chief deputy bailiff informed us that he's being instructed that our client, Mr. Patrick, has to be shackled. And I don't know, and I didn't know yesterday, and I didn't know the day before, and I didn't know the week before, whether or not we were going to ask Mr. Patrick to step down and demonstrate, and I still don't know the answer to that. I might not, but regardless, the way that the witness stand is positioned where the jury comes into the courtroom, okay, so they could very possibly see it, and he has brought this up. The thing is that the judge acknowledges this and says, she goes, "I know what your problem is." She's like, I got you, fam. I can read between the lines. I understand right here. I understand your point. You don't want the juries to see the shackles. Is that right? Yeah, maybe, Judge Chica. No, her name is Judge Chica. N-E-M. C-H-I-K-A, and then it's, N-E-M, like N-E-A-N-Y. I am. Mr. Clancy, I don't want them to see that, and I'm asking the court to I understand your point. You don't want the juries to see the shackles. Is that right, Mr. Clancy? I don't want them to see that, and I'm asking the court to overrule the sheriff's department, which she had the power to do, and she acknowledges it, and let him remain unshackled during his testimony while he's up on the witness stand 3 to 4 feet from the jury box. The court, all right, thank you. Now, yesterday before the defendant took the stand, this is the court, defense counsel had informed me that the court had that informed the court that he anticipated that the defendant, oh my God, how many modifiers? Okay. Defendant would demonstrate to the jury, his positioning and what he did in the room at the scene of the incident involved. And taking that into consideration, the defense wanted the defendant unshackled. And so the sheriff's department was very reluctant to do that. And as counsel well knows, the sheriff's department is in charge of the prisoners or inmates. They have control over the body of the inmate, how they handle the inmate, whether shackled or other security measures. Not in your courtroom, ma'am. Court has nothing to do with that. Stop. Stop it. Stop being intentionally obtuse. Stop being disingenuous. And so, pursuant to that, she's trying to blame it on standard operating procedures, going, well, they just can't control it. Government finds a way to control a lot of things that don't belong to them just fine. And get away with it. And I mean from all walks. The sergeant, the bailiff supervisors, and asked in light of the fact that the counsel is intended to ask defendant to demonstrate in front of the jurors, the court asked that the bailiff supervisors if they would make an exception to that, which they graciously agreed yesterday, and had to recruit other sheriffs. You notice that there were a lot of sheriffs, but we can go with was too. In the courtroom yesterday, I do it all the time though, so my modifiers I screw them up too. Was a lot of sheriffs in the courtroom yesterday when that happened. Today it appears that they are no longer intending to unshackle the defendant, and I haven't heard any reasons. I mean, this is the first I'm hearing. So Deputy Smith, would you explain to the court why we are in this position now? Deputy Smith, because my sergeant, he told us this morning that he told me yesterday, actually, he was going to talk to you. I'm sure he didn't get to it. He wasn't able to talk to you yesterday about it because of how busy we were. But we usually have, when the defendant is in custody, he has to have shackles on. It doesn't matter. We made the exception yesterday because the defense said the defendant was going to demonstrate what happened. And that's fine, but that's not our procedure. It's in our SOP. If he's in custody, he has to have shackles on. Well, your SOP and like constitutional rights, they may butt heads from time to time. And you just have to learn to, get over it and try to, find alternative solutions to your problems. Where's a ball gag when you need it? I'm kidding. The court. Okay. And so the defense has, let's see, that was page, 7? Yeah. Okay. So, excuse me for rubbing my eye so much. Itchy. Oh, man, it feels good, though. Oh, man, it feels like a scrap. Oh, it feels so good. Okay. Sorry about that. Dig in for gold. I gotta go wash my hands now. Not that bad. So, pass the defendant. Okay, I asked just both. I was thinking off the record. If the state anticipated that they would require the defendant to get off the stand and demonstrate in front of the jury, Miss Mitchell, my favorite person in the world. Okay, she's not my least favorite. The state has no intention. The court, okay. And the defense is saying that they don't know if they will or they won't, Mr. Clancy. I can't answer that question until I get to recross or redirect the court. Okay, and the court has taken measures in this courtroom to make sure that the jury doesn't see the defendant shackled. If you notice, in front of the defense table during voir dire, there's a little piece of wood there that ensures that the jury doesn't see the shackles. Let me repeat that. This is the court. The court has taken measures in this courtroom to make sure that the jury doesn't see the defendant shackled. If you notice in the front of the defense table during voir dire, there's a little piece of wood there that ensures that the jury don't see the shackles. And also, while the defendant will get back on the stand before the jury comes in, so they won't see him walking to the stand, while he's there, while the jurors are coming, the deputy will stand right there to make sure that the jurors don't see the shackles. And so the court has taken measures for that, and it has worked. Guys, it has worked. Judge Sheikha tells you it has worked. She knows it. She knows it. She knows it. Mr. Clancy, I don't know how we would know it has worked unless the jury has been asked whether or not they see. Which is exactly why this issue exists and why people aren't supposed to be prejudicially held in front of jurors. And the thing is that you could say, well, that's for sentencing. No, it's talking about shackling. The issue is shackling. The fact that it occurred in Deputy, Missouri was about sentencing. Fine, that was but when he testified for 2 days in his own defense, and then they suddenly shackle him on the third day, they're making him look like a flight risk, or that something happened between yesterday and today that required him to be in leg irons. That's a mischaracterization. It's not okay. And I'm glad that Mr. Clancy did point this out. I mean, since he didn't point out the third-party DNA, I mean, he should point out something, because the thing is that it could have been an alternative theory. So let's see, that is that one. Did I do that one? Okay, there. Let's just do that. So let's see. Here we go. And so I'm going to require, she said, since the sheriff is not willing to unshackle the defendant according to the policies, and the court, I mean, the court could very well order him to be unshackled. However, I don't see a reason at this point. I mean, he has testified to how many hours of direct examination, and the defense did not require him to get off the stand. Mr. Clancy, Judge, that is precisely my point. He has been on the witness stand for 2 days, right? 7-hour direct. He's been in this courtroom for 2 weeks. And I think that the court has some discretion here. And part of your discretion is recognizing his behavior throughout this trial, which has been nothing more than respectful. The court, I have no doubt that, crosstalk. The court, hold on. I totally agree with you. The defendant has not given the court any reason to think that he would be a flight risk. However, at this point, taking into consideration the sheriff's policy and the fact, Mr. Clancy, who's not here, the court, that neither side up to this point, let's see. I mean, it's just wild to me. I mean, talking about putting a piece of wood in front of somebody's feet, and it's like, oh yeah, and like, it's cool. Trust me, bro. No, I think I won't. This point is require the defendant to get off the stand and demonstrate anything. I'm going to let them the status quo remain, okay? Mr. Clancy, the last point I'd like to make, Your Honor, I will stop talking, I promise. It's my understanding that, okay, let's see. It's my understanding that when the jury comes into the courtroom, they will enter right next to the witness stand, and we all stand for the jury. But this procedure, you are going to have Mr. Patrick not stand for the jury, but rather remain seated so that we, I guess, minimize the chance that the jurors can see the shackles. And to that, we would object also. We would object. Boom, there we go. Thank you. Boom, 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 boom. Look at that. Look at those words. Object also. So much. So much. What's up? We think it's important that the defendant show the proper respect that the court requires when standing for the jury. That's what his attorney said. That if he didn't stand. Let's see. Okay. There's another issue brought to our attention that he was not going to be allowed to have water. So they also weren't going to give him water because they said that they were slipping booze or something, or trying to poison him. It's like, guys, like, stop it. I'm trying to find that page. But basically they determined, yeah, fine. We'll give you your water, you scummy killer, and see how it is. I mean, just the minds were made up. So you have this going on, and then 40, what was it? This is the 20, what did I say, 23rd? And then what was it? Let's see. Oh man, I can't figure it out right now. But the point is, within, days of that, then before that, you had jurors expressing doubt on the elevator. And then you followed up with this. I mean, like, this just seals that. I mean, I think they knew that they had a little bit of a possibility to spin this a little bit, and they did the best they could. And I think they did a very good job falsifying information and not keeping that courtroom a kosher house. It's hot. I gotta turn on this air conditioning. So I'm gonna play a video real quick. I'm gonna go grab some water and probably get a cup of coffee. I'm gonna put a video on of one of the things to kind of give you a vibe for that. Not a vibe, but a feeling of their arguments so that it makes sense. Let's see. Just one from that night. Oh man, I feel like I gotta sneeze again. How much? Let's see. Is that the conversation with his mom? I think it's a conversation with his mom. Let's see. Okay, not that one. I'm trying to find it, but I might be SOL. I need to get these. I need to finalize this stuff, but my own life and stuff to kind of press into. And I need to clean out my files and whatnot because I'm running out of space to keep going. So actually, I think I'm going to call it for tonight. Anybody that stuck around, I really appreciate it. I want to try to do this every day. I'm going to come back on. I'm going to stream later on. I've got some things I got to take care of, but I've got some transcripts and videos and kind of would like to walk through some of the just portions of it to, I guess, illustrate that this was really, there was information that was not accurately portrayed. There was misinformation. There were straight up lies, and a man is serving 72 years for not dying first. I mean, that's the best way to put it. I can't say that he would have stayed away forever. I mean, I'm sure that in his cell right now, he's thinking, yes, I would have, but I think he loved her dearly, and that they just were in a couple of toxic cycle loops where it would always go back to them. I mean, even if it was a year later, getting back together. And unfortunately, now he's paying the ultimate, well, not ultimate, but a pretty heavy price. And I do think that if the shoe were on the other foot, and if Janine were alive and James was dead on that floor, I would not be covering it like this. And she'd be out there doing her thing. And I have spent a lot of tears on this, a lot of time, a lot of energy, because it's what's right. I'm team truth. Because I want to start going through all the trial testimony today, I guess technically Friday. I want to go on a little bit later. I want to see if that being said, it's going to be on or anything, but it's not. I'm definitely going to go back over. I'm going to start with Shireen's testimony, but because, I would like to express this so that other people know more. Bye. I'll see you later. Okay. I love you. I'll see you later. Have a good night. Yeah, I got to crash too. I'm about to crash too. I'm going to start going over the testimony tomorrow because why don't we all go through it, right? So that's what I'm going to do so that we can start fresh because, again, I wasn't there for it. So if you want, there is a stand for James Patrick on Give, Send, Go. I am still going to continue to try to crowdfund for legal representation. I'm lowering my expectation. I mean, not lowering them, but I just know that everybody has their battle and the stuff that they are advocating for. And these people, as far as everybody else sees it, they just stay in this relationship. So why do you want to help a dude like this? Well, because I guess I just say, I hope I'm the walrus. I hope somebody would do it for you. So if you can contribute to that, awesome. It's good. You sit there until there's enough to to hand it. I would really like to hire Gary Edition, but he costs $40,000 men. And unfortunately for a lot of people, stand your ground and you were in a relationship, you knew what you're getting into. That's enough for a lot of people. So, but I know that we all have our moments and we wish that people would give us the grace that we want them to give us. So I'm going to go over that more tomorrow, but I thank you for sticking around this long. We'll see how this shakes out. I could see the Court of Appeals affirming the trial court's ruling and basically saying that having to rule on James's motion to reconsider is moot at this point because his attorney had filed his SIR reply. Well, they were both filed the same day, which is this isn't a bottleneck. So really, I think that as much as they don't want to answer it, that they need to answer it, the question, and that there need to be better procedures in place for indigent clients specifically when it becomes evident that there's been a total breakdown in communication. The Court of Appeals need to be willing to accept pro se filings without a preconceived prejudice that, it's just somebody pro se that doing it. It's like, well, it may be, but why don't you read the fucking document first? And then we can go from there to see if it's something you should grant, that you should look at, or that you just don't want to fuck with. But I would much rather you be honest and just go, yeah, I'm not feeling it today, denied, rather than just responding to his attorney's motion which was completely fabricated. I mean, built on fabrications, and give him this, you know, this floral response about, well, but we don't have to. He doesn't have a right to self-represent. Well, guess what? He wasn't asking for it. So James has asked his attorney to file an official motion for withdrawal. And the thing is, if he doesn't want to cite everything because he's embarrassed of his piss poor behavior being uncovered, then he can do that. And the fact is that we can keep going, because I don't like the fact that I've had to do a bunch of the work, basically, or you know, the makeshift equivalent of some of the shit that he's had to do. I've had to give his client documents while he's the attorney and he's responsible for the file. I'm not about that. I'm not about him lying to the court about what he did, the reason for the motion to abate, to pause it. I'm not okay with him saying that I said that James was willing to proceed pro se. That saying that he wants to address a couple things with the court, that doesn't mean pro se. That means he wants to talk about what you are failing to do as his advocate. So, here we ride. I mean, I think that, when somebody is in a tough spot, that you want to stand up for them. So I'm just trying to do it for me as much as I am for James. And if any of this is interesting, share it with people that you know or like, or people that you think may be interested in it. I'm going to work on some shorter form content, and I'll do some additional videos on those portions. I've started to look at the 3 men that she was hanging out with at the rodeo bar that night, because there are glaring discrepancies in their testimony. And just interestingly enough, James's defense counsel had hired a private investigator who they told a very different story to. Once they finally the cops got to them, which was later, their story changed a lot. So I want to go over those inconsistencies and some other stuff too. But I think we're probably going to go linear. I'm just trying to kind of feel it out. But until then, I appreciate your time. I hope that this was interesting to you, or it's somewhat informative. Anybody that's helping anybody else pro se on the inside, just keep showing up for them, and temper your speed in the race. Going faster is not going to get you there faster. The system's a process that takes time, as we all know, but it takes its time. Just make sure the court is not going to tell you, not going to provide legal advice. Their attorneys are reticent to do so as well. So read your local rules. I always go back to the code, go to the case law, and just be vigilant, and don't give the state an inch ever. Even if they want to put a picture of the deceased up, they're not doing it to be nice to you. It's not going to help you. It needs to come down. So just a lot of things like that. And yeah, we'll keep going. It's a lot, and it's hard for me to summarize. So I appreciate anybody willing to provide feedback on the matter. And I hope everybody has a great rest of the morning and a beautiful, fabulous Friday. Until then, peace out. Be well.